Hey, everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. This time we are talking about Trump's trial again, but this is week number 3 that has been concluded. So we've talked about week 1, week 2, and now we are on week 3. And as anticipated, there's always excitement in it. And we have 3 new topics we're going to discuss, and maybe a 4th if we get to it. So what we're going to talk about is the gag orders, the ruling that was made by the judge this week regarding the initial violation allegations, any potential new ones, as well as Trump's Fifth Amendment right not to testify. We will also talk about Hope Hicks testimony. We think that's the most important part of this week's testimony. So that's what we're going to talk about, with maybe a mention of Michael Cohen in the testimony without Michael Cohen. I'm Virginia Tehrani. I'm with the Law Unscripted, which is hosting the Legal Weekly Wine. And I am also the attorney for Tehrani Law LLC, because you never need a lawyer till you do. Now, joining me from Tehrani Law LLC as well is my colleague and partner, Chelsey Rogers. Welcome with us.
Hey, everybody. Glad to be here. Got a lot to talk about today.
Yeah, we do. And Chelsey, you're also one of our partners with the Law Unscripted. Yes. And I think it's worth mentioning there because we are in the end of law school season for third-year law students. And we know you're about to be studying for the bar. Yes. So go to www.thelawunscripted.com to find videos that Chelsey and I have recorded for bar prep examinations. We've done a lot together. So if you like the conversations we're having, I think you'll like the way we've approached it for supplemental classes. Check that out and like and subscribe to our channel to get the hottest legal news. And for our third party, we have Dr. John Weil, who is the Dean of the Honors College with Middle Tennessee State University. He's a Constitution scholar, the Amending Process scholar, a constitutional law scholar, as well as pretty much everything else you could hope and want to have in an expert. So we're privileged to have you here too. Thanks for joining us.
Thank you. Now, let me ask a question about your bar exams.
Oh, heavens. Go ahead.
So I know a person can buy individual sections, right? They could do like corporate law or contracts or torts.
Absolutely.
What if they get halfway through and then decide they want the rest? Do you still give them the package, or do they have to, are the parts greater than the whole greater than the sum of its parts or not?
Thank you for that question. And yes, overall, if you do an all access pass, which is the entire program, it's definitely cheaper than buying, pieces of it and then deciding to buy the rest. So there should be a way to do an add-on to include the entire all access pass if you choose to. But if you find that there's not, we have an email that you can use. Please email us and we will make sure that you can do that. We want people to have the access that they need. So yes, and I think it's interesting that you mentioned, and good that you mentioned, the individual pieces, because the other bar exam products, like Barbary, Studicata, those other Quimby, those programs only allow you to buy the entire package. Whereas for us, if you only have problems with property, need a little extra help with that, you can go in and buy just the products for property. So it gives you the ability to pick and choose the products you need. But yes, buying the entire all access pass certainly gives you a better deal and more savings than buying just individual pieces. So yeah, and even Dr. Weil, you helped us with that. You were on the constitutional law section. So if you like the way that Dr. Weil speaks, you can definitely join us for that. And I will tell you, your knowledge and your memory of even dates for these cases, these case names, the dates, I just can't do that. You were
teach
perfect.
It long enough, you learn.
Okay, and you're giving away your age. So watch out for that. And for everyone else, we're going to be doing a second video this week. It's hard to keep track of all of the news, and the Trump trial is a piece of it, but there's still the world going on out there. So we're also going to have a video. Please join us for one about the campus protests. So we're going to talk about that, and Dr. Weil is key to that piece of it. All right, so let's get into Trump's trial week 3. There we go. Chelsey, we have had these gag orders, and I would love to hear your opinion. Tell us what the ruling was from the judge that we've been anticipating regarding his alleged violations of the gag order, and then tell us what you think is happening with it.
Okay, I'm going to stop you really quick. What are you drinking?
Oh my goodness. See, I forget. I get excited about
I
what
know.
we're
I'm sorry.
looking
I'm sorry.
for. No, it's okay. Gag order's coming up. Thank you. It is the weekly wine. I am drinking wine. Grab a glass for happy hour. Don't do it for your commute in the morning, but join us later for the glass of wine. I am drinking this time. I'm drinking another Moscato. It is Marisol Winery, California. 2020. It is delightful. It is light and refreshing, a good summer wine. So that's what I have. Chelsey, what are you drinking?
Okay, I'm really excited about this one. I've been waiting. Okay, so we all know I love my box wine. It's not a surprise to anyone who's watched the show, but I tried something new. So it's still Franzia, but it is something different. I'm going to hold up the box so you guys can see I'm not lying. It's called Sunset Blush, right? Okay, we see this here. One of the
Sounds
best.
like a lipstick.
I know, right? Doesn't it? I saw on
does.
TikTok this woman who does like food tasting for her job. And she was like, one of the best things I tried this week was this wine. And I was like, boxed wine, new flavor. You got me. I'm in. It is so good. It's like a Moscato, but like not quite as sweet. Love it. Refreshing. Perfect for summer. So that's my recommendation this week.
Wonderful. And Dr. Vile?
I have genuine tap water.
Woo!
Oh, not even a bottled water today.
No, I ran out. So
Yeah, and I will say I don't love your tap water. When I visit in Tennessee, whether it's Tennessee as a whole or just your region, I have trouble drinking it.
well, everyone from Memphis, and I haven't been there for a while, but they all brag on their tap water there, that it's very tasty. So
Okay, well, we'll have
you
to
might try that
that
if you get to Memphis.
Absolutely. All right. Cheers, everybody. And Chelsey, especially to you.
Great. Thanks. Okay. So the gag orders. Unsurprisingly, well, unsurprising to me, the judge found that Trump had indeed violated the gag order repeatedly, and he fined him $9,000, I believe. Don't quote me on that. I believe it was 9. And threatened, as we sort of talked about last time, that if he keeps his antics up, jail could be in the future. We'll see.
Are you surprised that he was just fined and not jailed for these initial violations?
No, I thought it would be really hard to. I didn't think the judge was going to put him in jail this time. Now I do think if he continues on, that's in the future, but I expected it to be a fine. I actually kind of expected him to fine him more, but hey, it is what it is.
Yeah,
Yes, good. Go ahead, Dr.
Under
Baum.
New York, I'm sorry, under New
Oh,
York
tell me
law, as I understand it, each offense, the maximum penalty is 1,000.
Well,
So,
okay, yes.
and he was convicted of like 9 out of 10.
Mm-hmm.
Right. I guess in my mind, I was like, I think he did more than that. I think you could, I think he did more than that. So I think that number could go up, but I'm not the judge here.
Well, there are 4 more, I believe.
Correct.
That since they had the first trial are now also questionable. So he could get another $4,000.
Okay.
And if, I think then if we start talking particularly multiple infractions, then we could be looking. Probably if we get jail time, it probably would not be overnight. It'd probably be, stick him in the clink for an afternoon or a morning or, preferably they do it on a Wednesday and he can't go out and campaign.
Campaign.
I mean, that would cost a little bit to be a little bit more pain, I suppose. But we probably ought to clarify, what the gag order is and what it's not. And
sure.
Chelsey can probably do as good a job as that as I can.
Well, I don't know about that. You're the expert here, but the gag order is just that he can't talk about witnesses sort of outside the trial or, the list of people, the judge's children, the other court staff. But unlike what seems to have been said, he still has a right to testify. He has a right not to testify. Has nothing to do with his own testimony in the case. So a little confused on why that was sort of put out there.
Well, this goes back to our earlier discussion, and I'm afraid to say how I voted because eventually one of us is going to be proven wrong. But the two of you, if I remember, said you believe that Trump is going to testify in the trial.
Yes.
I said he wasn't.
Mm-hmm.
And of course, and we still don't know what will happen. But it seemed to me that when he said, I'm prevented from testifying at trial, that this was his way of sort of backing out and saying, well, I wanted to testify, but they
Yeah.
wouldn't let me. But this has nothing, you know, Constitution, Bill of Rights guarantees you a right to be confronted with the witnesses against you.
Mm-hmm.
So, and it also guarantees that you have the right against self-incrimination.
And
So
the right
if he
to remain,
thinks this-
exactly, the right to remain silent.
right. In a criminal case.
Right.
And so if he thinks that his own testimony might work against him, he's not required. And even if he thinks people just aren't going to like me when for whatever, I mean, it doesn't mean that you're guilty if you do not testify. But you have the right to testify, or the right in a criminal case not to testify.
Right. And that's one of the things that that he's put out that is wrong. And I don't know, honestly, I can't tell whether he just genuinely doesn't know the law and
Well-
is putting out what he thinks, or if he does know the law, but he's trying to rile up the crowds.
Right. Now, the judge, by the way, has corrected this.
Mhm.
The
Yes.
judge, when the trial started, said, you know, there's been some discussion of what this gag order means. To be clear, it doesn't require nor does it prohibit the president from testifying at the trial.
Right. And that
He's
was
trying
on
to nip it in
Friday.
the bud.
Well, and I appreciate that because it was Thursday. Donald Trump made the statements of, you know, this gag order is preventing me from testifying. They're trying to prevent me from testifying. And then exactly Friday morning, the first thing out of the judge's mouth practically was, let's talk about this. I am not preventing you from testifying. The gag order is specific to what he says outside of the courtroom when the court is not in session, is while you're in the media, you can't do this. And Trump even had pushed back of, well, what about, you know, you're preventing me from speaking at a campaign, from getting campaign speeches. And he said, no, I'm not preventing you from giving a campaign speech. I'm preventing you from talking about the witnesses in your trial. And I'm preventing you from talking about the court staff, the court families, and the jurors.
So I heard an interesting question this week that has bothered me and I still can't answer. And you may not be able to answer it either. So you probably shouldn't let me ask and then show that we don't know the answer. But what I find fascinating about this case is that Cohen is continuing to talk about the trial. But what's even more, and I'm not sure why Cohen should be able to attack Trump and Trump not be able to attack him. But the other thing, and again, Virginia, particularly with your criminal trial experience, maybe you can help us with this, but typically witnesses are sequestered for a reason, right? I mean, in a criminal trial, you would not know what others have said because then you could change your testimony so as to avoid contradiction. And Cohen has an advantage in this case in that the longer they wait and the more it's reported, then he knows what everybody has said before him.
Right.
And I don't know, you would think under those circumstances almost that he would be sequestered from listening to the news as much as any jurors would. And do you know why? Apparently there's no such sequestration occurring.
And that's a great question. Let me redefine some terms, though.
Okay.
Sequestering of individuals in a trial usually means you actually pull them into a specific location and hold them from going out into the public where they could possibly hear things.
Like a jury, typically, yes.
Exactly. Nobody's being sequestered.
Right.
The issue is, can they be prevented from listening to the trial like you're talking about? What we usually call it depends on the state as to which rule number it is.
Right.
But there's a rule on witnesses in a trial that's always invoked. The witnesses are excused and excluded from the courtroom, where you're absolutely right. They are not supposed to be listening to the other witness's testimony because there is the fact that it could influence what they say. Oh, I heard this person, they're a liar. That's not true. The only times those are usually accepted is if there's an expert witness who needs to hear some kind of testimony, usually a psychologist or a forensic scientist, to be able to later say, I heard their testimony and it contradicts the evidence that I found, or it contradicts a statement they made previously. But those are with permission of the judge. They're usually, discussed before trial to have that permission or not. And if the witnesses aren't excluded, yes, I think that Michael Cohen should be prevented, that there should be something like a gag order to prevent him from watching the testimony or listening to it from the news reporters and making a comment on it. I don't know New York law,
Right.
but I will tell you, I think if there is a rule in New York, that it should be exercised, and it's the defense's job to request and enforce it.
Okay.
The prosecution, who cares? Right? They want their own witnesses listening and hearing. Nobody wants them to lie. And of course, the prosecutor would say, don't.
And I think I'm right on this. I mean, I think usually within a day or two, you can actually read the transcript
Yes.
of the entire trial. So it really does, in a sense, give Cohen an advantage with his testimony. It's probably one that he'll need, by the way, as we'll probably discuss.
Well, and that's the thing is, if you don't want the witness to be listening, to be talking to others, because usually the judge instructs witnesses, do not talk about the testimony with each other. Do
Right.
not talk about your own testimony with anyone else. So I believe that the judge probably gave those instructions to any witness, but because they didn't all file into the trial, it wasn't an open one.
Right.
So it would be up to the defense, because he's not a defense witness,
Right.
to let the judge know in a courtroom setting, in the actual trial, before we begin, there's a preliminary matter. A prosecution witness is listening to the testimony, is listening to commentary on the testimony, and is making public comments about that testimony. That's against this rule on witnesses. And we ask that he be fined, that he be conflicted, that he be ordered to XYZ. So my question, what I don't know as well, is my answer is usually there's something to prevent a witness from doing that through this rule on witnesses. My secondary answer is it would be up to the opposite side that's calling him to invoke the rule on witnesses, to make a motion to make the witness stop in some form or other. But I don't know if there is such a rule in New York. Chelsey, what's your take on it? You're another trial attorney.
Yeah, I don't have quite the amount of experience you do. I was actually thinking, even I was sitting and listening to family court, and the judge, even in that scenario, which is, much less high stakes, was like, nobody here can testify. Are we sure we don't have any people? And I was just there, observing. But so I think it's very strange that we have this sort of scenario where they're, publicly commenting, one, and then two, being able to get not only the transcript, as Dr. Weil mentioned, but also the reporting, the coverage on it, right? You're getting sort of all the hot takes. I think this is sort of my overall take about everything with this trial, is that I think it's nearly impossible to sort of preserve the idea of like a fair and impartial jury and trial, just because of the chaos around it and each side sort of using that to their advantage in various ways.
Yeah, I think the other thoughts that I have as a trial attorney for over 18 years is that there's the ace in the hole where the prosecution may not actually call Cohen. I think they have to.
Yeah.
But at the same time,
that'd be funny.
If they're not calling him, then they don't care what he says in the press, right?
Right.
They don't care what he hears and what he doesn't hear, because maybe he won't be testifying. But I don't think you can presume you're not and just cross him off the witness list. So I think he stays on the witness list and would still have to be told, you can't talk about your testimony with anyone else. So I do think it's a violation. My stronger shock is that the jury still has not been fully sequestered, which is to take them out of the public, put them in a hotel, take away all of their electronic ability, including their phones, and tell them, we're not going to give you access, because I think it is more likely Not that I think jurors are terrible people. I love jurors. They're the way that the system works, but they're human too. And this is such a crazy trial and a big one that it's, your phone comes up, you turn on Google and there's a couple of stories. Even if you don't read the stories, if you're looking at Google, you can see the headlines. And it's hard. I think it's harder to prevent the jury from reading these hot takes, just as, Michael Cohen is. But I do think Donald Trump has a fair argument on that side of, hey, if this witness who's supposed to be in my trial can say whatever he wants in the press, why can't I? And I do think that's the best argument that Trump has in defending himself on the gag order.
I think maybe this is how I see it. And I agree. Like, it's not fair, right? I think I see the slight differences is that, like, the person's rights who are trying to preserve the fair trial for are Donald Trump, not Michael Cohen's. Like, right at the end of the day, the rights that we're trying to preserve and protect are Donald Trump's on his own. So I think there's a slight difference there that he is the defendant. Now, obviously, I think everyone is using all of these strategies to their own advantage, but I think that's the only distinction you can kind of draw in that at that point.
And Dr. Vile, Chelsey, I think that's a really great point to remember is the specifics of who Donald Trump is as the defendant versus Michael Cohen as the witness. Dr. Vile, in looking at the Fifth Amendment rights that a person has, is it truly just the defendant? And what does it encompass?
Well, I mean, in a criminal trial, you have the right not to say anything, not to testify if you think your testimony could be incriminating. Or frankly, that means even if you think you're going to, if you're cross-eyed and you're afraid people are going to see you're cross-eyed and distrust you, you don't have to. If you were an African American and you just thought everything you said would be, there were times in American history maybe where you wouldn't have testified. Now, in a civil case, as I understand it, you don't have a right. Not, if someone is suing you, you can be compelled to be on the stand. Correct. You can be evasive. You can claim not to remember. The problem with that strategy is it typically undermines somebody's credibility.
Right.
But that's, to go to a case that we mentioned not long ago, the O.J. Simpson case. In the criminal trial, he did not testify.
That's correct.
And there was a heavier burden of proof beyond reasonable doubt. In the civil trial, he was forced to testify. Now, again, whether he testified, how convincing it was, but he was convicted. Well, convicted is the right word.
He was found liable.
Right. He found liable on the basis of a preponderance of the evidence. And part of that evidence was his own testimony probably did not come across very credibly.
Right. And I think it was his own attorney, Dershowitz, who made public statements recently of, I told him not to testify in the criminal trial and he didn't, and he won.
Right.
But then he testified in the civil trial and he lost.
Right. But he had no choice on that, right? I mean, you can be evasive, you can lie and take the chance of being tried again for perjury, but you don't have the same right against self. You're not incriminating yourself. It's liability.
Yes and no. So it's funny. If the civil trial had occurred first, he could have invoked his Fifth Amendment right against self-incrimination because he was still on trial for crimes, and what he said could have implicated him criminally.
Well, you get the same thing in congressional testimony. If you remember, well, you probably don't remember, but when Oliver North was called to testify about an arms for hostages deal with Iran, he testified and later was exonerated in a trial on the basis that the prosecution had garnered information from the testimony for which he had presumably been given immunity. And so that's a good reservation that you've made, that the order of the trials does sometimes matter.
Right. And for O.J. Simpson, after he was found not guilty in the criminal trial,
right, then the
judge would say, you can't incriminate yourself for a criminal matter because you can't be tried again.
Right.
Double
You have
jeopardy.
to testify.
Double jeopardy. Yes.
Correct.
Another hallowed constitutional principle.
Yeah, in my own civil trials, I do a lot of personal injury, and for for a drunk driver who hits an innocent victim, I represent the innocent victim. We put the defendant on the stand because we can. If he has not yet been tried regarding drunk driving, then he can refuse to testify because of self-incrimination rights, not to incriminate yourself. So we try purposefully to wait until the criminal trial is over before we do the civil trial or even file a complaint, because at that point, the justice system has worked in the criminal part of it. He's either been found guilty or not, and whatever he says, he cannot be criminally indicted because it's already done.
Right. The only problem with that is by the time if he has to pay for his own lawyers, he's probably bankrupt by the time you get there.
Right. We get no money unless he had insurance. True. And the other thing is, if he was found not guilty for the drunk driving, then it makes my case much harder.
Right.
Absolutely.
Because somebody's been found not guilty in the criminal system. Well, then why should he be found liable in a civil system?
But just like with OJ, we know
Yeah.
that is not necessarily like, right, if you're saying,
true,
beyond a reasonable doubt or like more likely than not, that's a really different standard.
It is.
Like a
It absolutely
51%
is.
or like a 99%. Big difference.
True. Absolutely. More, just a little more likely than not versus beyond a reasonable doubt is huge. Okay. So Dr. Vile, I know that the next part of the week 3 of the trial that I think is most important. We had another witness or two testify. Davidson is one who I think is a very interesting witness, but we're going to pass over his testimony because I think the most crucial witness this week is Hope Hicks.
Absolutely.
Dr. Vile, I know you have a lot of opinions on Hope Hicks. She was the
I do.
last witness called this week. I think we ended with her testimony. Tell us who she is and why you're so anxious to talk about her.
Well, as I understand it, Hicks didn't start out in politics. She was working with Donald Trump, and I guess originally maybe with Ivanka Trump, or Melania. I'm not sure which one. I'm not sure which of whether it was the wife or the daughter, but she had been working for one of them. Basically, she's sort of a PR person. And I was listening to a very fascinating interview this week or discussion that apparently when Trump, and I guess maybe she actually testified this, Trump said, we're going to Iowa. Why are we going to Iowa? Well, he's decided to test out the caucus. And she says, well, what's a caucus? Which is to say, she basically was, I don't know if she was apolitical, but she wasn't, she was an advertising or whatever kind of major you would take. She wasn't a political science major. And she got, in my judgment, she just sort of got caught up in this situation. She's, now help me with the term. I want to say adverse witness, but there's probably a better term. Adverse, does that work?
Adverse is the great word. Adverse or hostile witness.
Okay.
Either one could be used.
Yeah. And what's interesting as I understand it, she remained loyal to the Trump family and really did not want to testify. She was subpoenaed. Is that right? She was.
Yes, by the prosecution.
Right. Prosecution demanded that she be there. As far as I can tell, and I wasn't in the courtroom, obviously, but it sounds like she testified very truthfully. And at some point, she realizes that, hey, what I just testified to suggests that Donald Trump was far more interested, and he did what he did far more on the basis of fear of losing the election than how it might have affected his daughter or his wife. And as you know, everybody who's listened to the news knows, she actually began crying on the stand. I think this was either right at the beginning or right before the cross-examination. But what I think is fascinating about this is these cases seem abstract, right? So we've
Yeah.
already had one case involving fraud. What is it? 500 and some million plus.
Oh, the civil case by the
Right.
attorney
Civil
general.
case. Right. And you're right. It's a civil versus a criminal case. But all through that trial, people said, well, so what if he said 30,000 square feet instead of 10,000?
Right.
What if he
It doesn't hurt
shaded a little
anyone.
bit? What if he overestimated this property and undervalued this tax liability? So what? There are no victims.
Right.
The state or the civil procedure did result in the court saying, well, money that you lent to Trump is money you can't lend to somebody else. If you let one person falsify records, you're creating so they showed. But in today's case, I mean, it's this criminal case is very similar. It's not a case of Trump going on Fifth Avenue and shooting somebody.
Right.
It's not even, as egregious as alleged sexual conduct that he's engaged in.
Right.
Not. So what is he accused of? Well, he's basically accused of paying hush money to a porn star. Now that's unseemly, both aspects of it, but apparently not illegal.
Right.
What is illegal is apparent if this was a way of helping his campaign,
Right.
and it is filed under something that says these are just regular payments to an attorney, that's falsification. But the point is, I mean, I want so big deal.
Right.
He lies. Business people probably do these things. I don't know. Hopefully not on a routine basis, but
Well, and you have a quote that I'd love to use here, and I don't know who said it, but you're always saying, how can you tell if a politician is lying
that's right. There's
if they're
lips moving,
talking, right?
Yes.
Yeah.
Or
So what? Dad, continue. And yes, my father, Dr.
well, and that what it brought to what, and again, this isn't itself a criminal offense.
Right.
You can
What
sleep
I'm
with
going
porn
to
stars and pay
say,
them off,
but
Right.
there are
It's your prerogative.
There are people that this conduct affects, starting with a wife, a daughter,
Right.
other business associates. And here, I mean, I have some, I wonder, frankly, over why Hicks has been so loyal.
Mhm.
He told her, no, I had nothing to do with this. You go out there, tell the press there's nothing to see here. Her reputation was effectively, in her mind at least, ruined. Nobody's ever going to believe me again. I said there's no fire, and they found a forest fire. I mean, about as bad as it could get. But she is still loyal enough, presumably maybe because of the wife or the daughter, that she's a victim here.
Yeah.
I mean, now, I guess I say she's a victim of Trump. I suppose maybe you could say, well, she's also a victim of the prosecutor here. I don't know.
Mhm.
She's being, brought into a case. But what a situation to find yourself in. I mean, it's a little bit like, frankly, it's a little bit like Mike Pence.
Sure.
I'm vice president, and you're telling me to do something that I think is illegal. And if I don't do it, people are going to threaten to hang me. I mean, there are victims in the, it looks like a victimless crime. It looks like a very innocent, well, he falsified a document or two dealing with elections. Don't people, give him a fine and let him off. But she injected, I think, this personal element in there that it no longer seems like it's just a paper transaction. Or if you look at Trump is saying, they're going after me for a mistake.
Right.
In a document that I signed. No, that they're alleging that you knowingly claimed it was for one thing when it was for another. And documentary, I mean, this is a crime. Now, but again, for me, it puts a personal face on it. It's like, this isn't just abstract. it's something that can ruin or mar people's lives. And I felt the same, when Cassidy Hutchinson, I don't know that she'll be on this trial, but when she testified before Congress, it didn't sound to me like she was doing it out of vindictiveness. I think Hicks, I think she believed Trump when he said, that doesn't sound like something that I would say. And the next day or, thereafter, she's listening to a tape where she hears him say it. That would be, if, especially as a young, you're a young person, think of it, I am press secretary, or whatever the title is for somebody who's about to become president of the United States. And suddenly you're left high and dry out there, promoting something that he's told you that turns out not to be true. So I really felt empathy, and I'm assuming jurors would feel the same, but I don't know that.
I think I'm so sorry, Virginia.
No. I was going to definitely call on you next. Let me interject something real quick here. You guys know I'm interjecting movies recently. We've talked about the runaway jury in regard to this trial. Have you all seen Fun with Dick and Jane?
No.
It was
I think I read that on fourth grade.
not those, but it does sound similar. I can't remember who the woman was, but Jim Carrey was in it, and it was very similar idea of he was in this company that they all of a sudden bring him in and promote him to the press secretary, essentially. And he's got this amazing promotion. They promise him all this money. He's rising up. He goes out to do a press conference, and he's left high and dry because nobody's told him that the company's going under. The whoever's are investigating the company and about to charge everyone. And he's there on national television talking about how amazing this company is. And all of a sudden they're like, well, what about this? And what about that? And everybody's running off on planes to escape America or whatever. But it's the same idea of someone's been promoted. They think they've got this great job. They were put out there and left to hang out because nobody else wants it. So anyway, just a movie out there, and then how he goes bankrupt and starts, selling his grass or whatever it was. But Chelsey, how do you think the jury is viewing Hope Hicks?
Yeah, I think what was and I agree with everything Dr. Weil said, because I think just because of her age or how she presents, I think a lot of that, especially compared when you talk about the start of the trial, they were, getting these sort of sleazy journal. They come off very, they do this all the time. They're very into this backroom deals, and just that, at least that's I'll speak for myself. That was my takeaway. I didn't really, feel whole lot of trust towards those people. I think she conveys a level of authenticity, and maybe a little bit naive especially in comparison with some of the other witnesses that we've seen, that I think really does, maybe soften, bring it back home. Because I don't think most people, at least, again, I'm just speaking for myself, I don't really find the sleazy backroom deals with the paper and the journalist, all that, I don't relate to that. But I think she comes across a little bit more relatable, I would think, to the average person than these other people. So I think it's interesting to see how that will impact their decision.
And then if we're going to connect to Cohen, that's the one everybody's waiting on. He's already served a jail term.
Correct.
We know he was guilty. He's told us that he lied and cheated and everything else for Trump. Right. And so if they put him, I think they've been very wise. If they put him on first, it would be very difficult.
They destroy their own credibility from the beginning.
If he now confirms, what she has said and others, I'm sure you've heard this expression, but I've heard this in some opening statements where prosecuting attorneys will tell you that we didn't, you're going to hear some people who weren't Sunday school teachers and deacons.
Yeah.
They're not the kind of people that you typically expect to be engaged in this kind of behavior. We have to bring them forth, not because we think they're any paragons, but because these are the people that are associated with this criminal act.
Right.
And I think they're doing a pretty good job, again, assuming they're going to call Cohen, of Cohen won't be there, the only one saying, well, this is what I did and how I did it. And everybody's going to say, well, liar, liar, pants on fire. They already know he's a liar. He's
Right.
admitted basically to being a liar, but he can probably confirm or not some of the testimony that others are giving.
I agree. I think it's a very good strategy, trial strategy by the prosecution not to have called him first. And I think we're all waiting for him, but I think it's still continued good strategy to put these other witnesses on. In some way, I think they're holding their breath because these witnesses, all of these witnesses are saying how awful Cohen was. They disliked him. He wasn't a good guy. He was out for himself. All he wanted was money. All of this contemptuous language regarding Cohen. And it's not just one witness, it's witness after witness after witness. So in a way, they're undercutting their own star witness before he gets on the stand. But Dr. Weil, I think that goes to your point of they're also establishing his credibility because they've brought up these other people to say, this is what he did. So when he gets up and says, this is what I did, the jurors already know.
Well, and there's also apparently a pretty good paper trail here.
Mm-hmm.
Now, what I think we're not necessarily, I think the hardest point to prove is did Trump know what Cohen was going to do before he did it?
Mm-hmm.
And then if he did know what he had done, did he try to cover it up in an illegal fashion? I think there's some evidence for that.
Agreed. You have to prove this is back to criminal law basics. The two things you have to prove are mens rea and mens rea and actus rea. What did they actually do? Was what they did a crime, and was their intention to do that crime? And I agree. I think this trial, the crux of this trial is what was Trump's intent? Cohen's intent seems clear and awful, right? We have the National Enquirer, the head of the National Enquirer. All of it seems sleazy. Everything is sleazy. But what did Trump know? What did he know? What did he want to do? What did he intend to do? Did everyone just act on his behalf of their own volition? Of we got to help him win the election, so we're going to make sure this deal goes through. We're going to make sure Stormy Daniels is paid off. Trump is here just thinking, well, I don't want my wife to hear this video. I don't want my wife to hear about these allegations. Or was it his intent to put these players into action so that they would affect the election? And this goes back to what is the crime? Yes, there's a crime in falsifying business records. That's a misdemeanor. It becomes felonies if the business fraud was done in order to influence an election. And that's the question. Why was this done? Okay, Michael Cohen, he did it to influence a campaign. Did Trump put it into motion? And if so, did he do it to save his reputation or to affect the election?
And this is where Hope's testimony, I think, probably was the most destructive for the defense, which when she was asked, and I wonder if there should have been an objection here as to speculation, but when she was asked, did you believe Cohen when he said he did it out of the goodness of his heart? And she basically said he doesn't have a heart, or
no.
I think what she said was he was not known for his charitable actions. Seems unlikely he would have done it just because Trump was such a good buddy with his.
Right. And that goes back to who's the victim, your question of that. And there's this amorphous, the idea of doing it to impact an election. Ultimately, the victims are the voters. Yeah. According to this law, the persons who are affected by this conspiracy, by this cover-up, are the voters. Where if they had known this information before the trial or before the election in 2016 or for 2016, would they have changed their votes? Would they, the wool have been removed from their eyes?
And one of the
that's
problems,
question.
and one of the problems with that is if the voters didn't reject Trump after Access Hollywood, is there anything they would have rejected him for? And that's part of the question that we have in this upcoming election. How much behavior are we willing to tolerate?
Right.
Legal or
that's true. Chelsey, I think this is a great place to ask you.
Oh God.
Just about this Access Hollywood tape. What is it? What impact do you think it already had? And what's its purpose in the trial?
Okay.
This is the salacious stuff.
Yes. Okay. And correct me if I'm wrong. I'm a little all over the place today. Y'all, I've been struggling. The Access Hollywood tape is the locker room talk, right? That's what we're talking about here. Okay, great.
Yes.
So I won't repeat what's said on that. I probably couldn't. Virginia would fire me. But apparently you can say it and be president of the United States. Clearly I have a lot of feelings about the fact that that was released pre-election and it didn't seem to matter. Like I said, I can't repeat what was said, but it was some stuff that I found, I personally, and I will say, I am very hard to offend. I found it extremely offensive that we had someone running for the highest office in our country that said things like that, specifically towards women. I don't even know how it was leaked. Maybe one of you guys do.
I don't remember. I know it was
how it was actually leaked, like how it came out. I don't remember.
I mean, what's important, what came out in the
Yeah.
sixth thing testimony is it came out shortly before these alleged payoffs were made.
Oh,
And
sure.
the people trying to get the payoffs realized that if he didn't become president, nobody would care.
Exactly.
And so if they had maximum leverage in those 2 or 3 weeks right before the election, and that appears to be when the payoff occurred. So that's where this link comes in to, was it for the to influence the election, or was it to protect his wife or daughter or somebody else?
Right, because it seems unlikely that, for comparing these two things, both not great, but that the payoff to Stormy Daniels would have more of an impact on the results of the election than this other thing.
What Chelsey said is important. I mean, I think I'm probably as offended by it as you are, but there was particular concern that women voters would be more likely to, that some guys would say, well, we've said, what Trump basically says, locker room talk, guys talk a lot. They don't really do much, nothing to worry about. But I think many women certainly, and I'm not justifying it either. But I think the fear was that particularly among women voters, that this really would be enough. And remember how close the election was.
Yeah, this was the first presidential election I could vote in. So this was really exciting for me in 2016. It was the first presidential election I was able to vote in. And yeah, I personally don't care who sleeps with who. I mean, I don't want people to cheat on their spouses, but as a voter, I'm not particularly concerned who somebody is sleeping with. However, the Access Hollywood tape, I'm a little concerned about that personally. Was real concerned about that one.
Exactly. And that goes to, and I'm not ignoring people. I'm going back to my notes of these. You guys are spot on, because the question here is, we talked before taping, there's Cohen's testimony is getting out there even without Cohen. And there's these calls between Davidson and Cohen, where Cohen continues to say, I want my money. What about me? I got to get paid. And it was the idea for Stormy Daniels as well, according to these recordings between Cohen and Daniels, that Daniels wanted the money more than you could ever imagine before the election day. Because if her story got out before the election day, then that's when it mattered. But if it came out after election day, then who would care? Well,
and particularly if he wasn't elected.
Exactly.
I mean, it might still be valuable if he were president and wanted to keep it down, but if he weren't, and remember how close not everyone will agree, but political scientists will tell you that in 2016, the popular vote was won by the Democrat.
Right.
even though the Republican won the Electoral College.
Right. And yeah, so for Stormy Daniels, she allegedly wanted this deal, right?
Yes.
To get her, she thought she was getting a deal to sell her story to be published before the election. Though the National Enquirer CEO says, no, we were paying her off so we could silence her story.
Catch and kill. Yeah.
Right. To kill the story, the catch and kill theory. And for her, the idea was, and this is what was played on the tapes, is she was concerned, she was pushing her lawyer to get the deal closed before the election because she was concerned that if Trump lost the election, they'd lose their leverage and her story would be worth nothing. So we can all see through this testimony that's coming out as everybody's sleazy.
She doesn't sound like a Sunday school teacher either.
She's not either. Nobody is in this story except maybe poor Hope Hicks. But
Yeah.
it's, why are they doing it? Are they all just sleaze bags? Or is it because they, she wanted her story bought so it could be told before the election. They wanted to buy it to silence it, but everyone knew her story could change the results of the election.
Right.
Just like this Access Hollywood tape. And I agree, as any, human, as a woman especially, but as a human being, the statements he made in this Access Hollywood video or tape about what he could do as a powerful man were extremely offensive.
They're disgusting.
Yeah, it's gross. Like, it's gross.
Yeah.
Like, I don't I'm sorry. Like,
I can abuse women because I'm who I am.
Right. Right.
Yeah.
That is just, and then we're like, hey, that guy, let's give him more power. Excellent idea. I'm sorry. Like, this makes me so mad.
Yeah. And that's, I think, where we go to end with here, the jury, go back to the jury, is there are 12 people who have his fate in their hands. And because this case is so complex with, who's the victim? What did he supposedly do? Is it a payoff, or is it a constitutional issue, or, election? The prosecution, I think, is still hoping that jurors without the legal knowledge can be so impacted by their own disgust of all of these people that they were willing to overlook or not understand the law and just say, okay, I don't understand it, but clearly he's guilty.
It's like jury nullification, but the opposite way.
Yes.
Like, it's
And
toward the
you have, of course, two attorneys on, one of the most fascinating, if there were ever a time where you'd like to be able to sit in on jury deliberations, this would be the one, because you want to know, are people going to defer to them as attorneys? And, and are they attorneys who are going to say, well, no matter how disgusting you found this testimony to be, it did or did not actually violate a law? I mean, that's the key. And it's a pretty unusual jury in terms of, I was always told as a college professor I would never be chosen for the jury. And the one time I was up, I wasn't. Although occasionally you'll see a governor, ex-Governor Brown of California was once called on a jury. Sometimes it happens.
One of the Supreme Court Justice Roberts was called for jury duty.
Other than the impeachment?
He was called for jury duty just
that.
in the normal course, because his name is on the voter registrations, right? I was actually called for federal jury duty within the last couple of weeks. And I thought to myself, well, this would be fun. Maybe I should appear. But there was a little part of, if you're unable to give us a good reason. I had quite a few that I thought were good reasons. And sure enough, this week I got an email saying, yeah, you don't come. So I was excused from the jury, but everybody gets pulled for the jury. And in this case, I would love to see, I wish we could tape the jury deliberation, because we found out in some of my criminal trials, we would talk to the jurors afterwards who would agree to talk with us. And some of them, they're influenced by the attorneys so much. And one of the craziest things that happened was it was a murder trial I was on as the prosecution. And the jurors, some of the women jurors, were focused on, there were two of us. Well, they coordinated their outfits every day. Didn't they look nice? They must have known what they were doing. They wore brown on the same day. They wore black on the same day. They were focused on what we were wearing. There were others who were saying, well, the defense just didn't seem prepared, so they must not have, whatever. So it's so interesting what a jury focuses on. And you can't guarantee and really should not guarantee that it's the law. So there's an importance of who you call, the order you call them in, the way you look, the way you present things, because you cannot remove the human aspect from a juror who's looking at everything
And
and
this, by the
everyone.
way, goes in the rest of the life. I remember a colleague here, very prominent woman administrator on campus, who went for an interview and wore a red dress. And apparently all the comments she got for the interview was she wore a red dress. And it's like, you know, you can't win for losing.
You can't.
Yeah.
One of the craziest comments I ever received when I was in law school, I was at William and Mary, and we, of course, went to competitions for mock trial, for, you know, fake trials to compete. We went throughout Virginia. It made the most sense, right? We did others, but I remember going to competition in Virginia, and this was early 2000s. And I will never forget, from a woman judge, if the mock trial, her comment about me afterwards was, "You wore a pantsuit." Ms. Vile, we don't wear pantsuits in Virginia as women. You should always, and only from here on after, always wear a skirt suit, because that's what we require in Virginia.
I remember when we undergraduate mock trial, we were always, students never, you know, you're picking on me. What do you mean I have to wear a tie? Or, you know, why can't I wear this? Because, yeah,
There's an
these are the
expectation.
intangible, you know, do you care about your trial or do you care about yourself?
Exactly. It's so interesting what people are judged on, and it's not necessarily the testimony or the law. It's, you know, what do people expect to see, and do you fit within their expectations?
And that's one reason, by the way, that you do have judges can sometimes set aside a jury verdict.
Absolutely.
If there's some kind of evidence of that, or, you know, if in their judge, I mean, right, they can even keep it from going to a jury if at the end of a trial, they don't believe there's adequate evidence.
Absolutely.
I mean,
Summary
and
judgment
typically
motion.
right after, so people will be prepared. After the prosecution offers its case, there will almost surely be a motion to dismiss on the part of the defense before calling any witnesses.
It's
and
standard.
Every news network will be out there and they'll report this significant development, and it happens in just about every trial.
Yes.
Right?
It's almost malpractice not to.
Yes.
Because you have to preserve your objections.
Right.
And if you don't object and say, you know, legally they haven't presented a case that would prove the law, then you've lost all, you know, all appealable issues because you didn't object to it. You have to
use it or lose it.
Yes. All right. So with that thought, we're anxious for week 4 and what will happen there. It's, you know, clearly going to continue to be exciting, at least for trial attorneys and constitutional experts. So keep up with us for week 5. Week 4 coming up. This was week 3 analysis. Join us for that. Don't forget to like and subscribe so that you can keep up with us. And don't forget the next upcoming video that we will also have during the week is regarding the campus, I want to say riots, which some of them have been, but the protests regarding the Israeli-Gaza war. So watch out for that video. Thank you both for joining us. And don't forget to continue to watch the Legal Weekly Wine, where we do discuss the week's hottest legal topics.